Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we have spent a tremendous amount of time lately talking about magazine bans and AR bans, and primarily talking about a lot of pieces of significant appellate litigation going on around the country and how it could affect our Second Amendment rights, and in particular, how the Bruen case from this summer from the United States Supreme Court has significantly changed the landscape for all of those pieces of litigation. Now, we recently talked about Maryland's semi-automatic rifle ban in this video right here, in a case that all of us are very closely following called Bianchi v. Frosch, which, yes, if that case goes the way it should, if the law is correctly applied, Maryland's semi-automatic rifle ban would be struck down. However, there is another case out on the other side of the country that we need to be aware of and we need to start carefully watching. So I want to get you familiar with that case today. So today, let's spend a few very important minutes and talk about the other case that could overturn assault rifle bans. Okay, before we get going down the road we're going down, proud to announce that this video is being brought to you by Legal Heat. That's right, the nation's largest educator of concealed carry classes. Legal Heat has now taught over 200,000 people around this country since they started doing this in 2005. Now listen, for my Washington viewers, you can find a class at any one of these locations right here. If you're watching from somewhere outside the state of Washington, congratulations. One, you are doing much better than we are and living far freer than we are. But number two, you also can find a class somewhere close to your backyard. All you need to do is visit them at mylegalheat.com. That's mylegalheat.com. Now listen, for any of you, regardless of where you are, if you find a class and you want to sign up, use the promo code Washington Gun Law. That's Washington Gun Law, all one word, and you will receive 10% off. So for more information, visit them once again at mylegalheat.com. Okay, so the case we're talking about today is a case that's in the Ninth Circuit. Actually, it's been kicked all the way back down to the Southern District of California, down in San Diego, with the Honorable Judge Benetiz presiding. And this is a challenge to California's assault weapon ban. Now, one of the things when you're reading legal briefs and you're geeking out like I like to do is you try to read the tea leaves and figure out, hey, listen, what's the other side arguing here? Are they making arguments that are well-founded in the law? Are they making arguments that are well-founded in fact? Or are they just screaming like a child, having a tantrum, and trying to kick the other side in the shins? And the latter is exactly what's occurring here, because the state of California is completely crapping their pants at this point. Because what happened here is that as soon as Bruen came out, Appellant's counsels very wisely filed supplemental memorandums with the court saying, hey, what are you going to do about it now? I mean, this rule of law is pretty clear, and it is very clear when you read Bruen. Now, of course, the state of California responded with, oh, no, the Bruen doesn't really mean all of that. It actually is a much more watered-down meaning to it. And that then allowed appellant's counsels here, again, those representing Miller, the appellant here, an opportunity to really take the California Attorney General's office to task. And listen, this is a complete takedown. Consider some of this. First, the state starts with the incorrect premise that Bruen somehow fundamentally altered the legal standard for evaluating Second Amendment challenges to firearms regulations. Second, the state attempts to relitigate the meaning of its own evidence when it claims that the ban does not permit arms per se, but it is some sort of a benign ban on accessories. Then the state attempts to relitigate this court's prior findings under the dangerous and unusual test by literally overriding the Supreme Court to manufacture a dangerous or unusual test, which is glaringly incorrect. Third, the state attempts to salvage yet another interest-balancing test in the aftermath of Bruen by somehow suggesting that its newly rebranded accessories ban does not actually burden the right to self-defense. Ultimately, the state has filed an oversized 77-page brief that cross-references thousands of pages, purportedly new evidence in the form of declarations and exhibits. Plaintiffs will not fully respond to each claim and evidentiary reference due to page and timing constraints. However, in summary, the state's new arguments and evidence to support their unconstitutional ban on assault weapons should be rejected outright as constitutionally irrelevant, unsupported, and evidence of the type that was expressly rejected in Bruen. And when you begin to see what the state of California is arguing here, you really begin to smell the desperation that is coming from these people with a gun-grabbing agenda, because California now is grasping at straws. They have seen the writing on the wall. The Bruen opinion is so well written, so well structured, and so clear in its mandates that, yes, the state of California is completely crapping their pants at this point. Now, one of California's many disingenuous arguments is once again, hey, listen, the Second Amendment was ratified in the late 1700s. Semi-automatic rifles didn't exist at that point, and therefore this constitutional amendment was never designed to protect these types of weapons. Now, that has been rejected time and time again, and despite the fact that they claim that they want to follow the rule of law, they seem to ignore that rule of law. But the court struck it down quite quickly with this. Considering the Second Amendment's text, the court affirms that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And of course, the court cited to the Bruen opinion as authority. Now, here were the arguments that the state of California is trying to make as to why Bruen really has no application to this argument whatsoever. The first argument, and this is a kicker, is, hey, listen, this actually isn't a ban on assault weapons. It's just a ban on accessories that go on firearms. So it's really the Second Amendment's not even at play here. That's right. That was actually one of California's arguments. This is how they dealt with that. These, along with all other firearms prohibited in the AWCA, are arms within the meaning of the Second Amendment's plain text, which presumptively protects Americans' right to possess, quote, all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. However, here's the problem on California's argument there. You see, they went back and they took a look at the legislative history of when they passed this bill. And of course, was it ever designed to be a ban on certain firearm accessories? No, of course it wasn't. In fact, those that supported this legislation, those that proposed this legislation, were incredibly braggadocious. They were spiking the football that no, this was intended to be a outright ban on semi-automatic rifles. So that's the first strike against that argument. The second problem with California's argument actually came from one of California's own witnesses. You see, at the trial level, they had called a so-called firearm expert who talked about the existence of pistol grips and other things that make firearms more deadly. However, on cross-examination, what he admitted to is what it really makes is it makes firearms more accurate. And in self-defense situations in which we have a particular target that we want to shoot and we really don't want to shoot anything else, accuracy, he admitted to this, is of critical and paramount importance. So it undermines the argument on those grounds as well. And then the third argument they made under this larger argument is, hey, listen, you don't need this type of firearm for self-defense. There's other types of guns you can do. And I was not persuaded by anybody's opinion here other than the United States Supreme Court when they specifically stated, state officials' beliefs and opinions are not entitled to deference. On the other hand, the choices of millions of Americans so demand are unqualified deference. Then, of course, in the final thrust to the heart here of this very disingenuous argument from the state of California that this is just an accessory ban, it's not a firearm ban, plaintiff's counsel very quickly pointed out, one cannot be arrested for merely having a flash hider in his pocket. One can, however, be arrested and subject to prosecution if the flash hider is attached to a centerfire semi-automatic rifle that does not have a fixed magazine, even in the confines of his or her own home. The second disingenuous argument they made was, hey, listen, the Bruen court says that there is a long and rich tradition and history, a historical analog, for banning dangerous or unusual weapons. And obviously, a semi-automatic rifle is incredibly dangerous, and therefore, these bans have historically been upheld. The problem for the state of California is either they don't read well, or number two, they're completely disingenuous, because the test has been that we have traditionally allowed for the banning of dangerous and unusual weapons. Not dangerous or unusual. It is the conjunctive rather than the disjunctive. And that is critical because let us not forget that the ATF themselves, in recent time, has referred to the semi-automatic rifle as one of the most popular firearms in circulation today for self-defense purposes. And honestly, when you have one side to an argument taking the rule of law and changing words in it and saying, well, actually it means this, that really does begin to demonstrate the level of desperation that's being shown here by counsel for California. And of course, if the test was dangerous or unusual, plaintiff's counsel correctly points out all firearms are dangerous, and it therefore follows that they cannot be prohibited merely because they are dangerous alone. And that is exactly right. And then, of course, the final argument that the state of California attempts to make is that there is a historical analog for this. Now, they come up with 17th, 18th century regulations on storing gunpowder. They talk about other types of dangerous and unusual weapons, but the laws they cite to were the manners in which you could carry them, not so much the ability to possess and or own. And essentially, they went on a scavenger hunt trying to come up with some type of historical analog, but of course, none existed. Plaintiff's counsel was very quick to point out, in starting its analysis, the state's brief first makes reference to medieval and pre-founding English history. And yet, notwithstanding an academically interesting discussion about the American inheritance of English law, the state cites to no actual law prohibiting the possession of specific weapons by their perceived dangerousness, aside from the highly vague references to due restrictions. But in the final coup de grace to this argument, plaintiff's counsel very wisely and very correctly points out, second, if ancient English laws prohibiting the manner in which concealable firearms could be carried were not good enough to uphold concealed carry laws in modern-day New York State, they are hardly relevant to a ban on an entire class of firearms that are widely and commonly held by Americans in their own homes. Plaintiff's counsel really wraps this up best when they argue, despite this clear instruction from the court, the state spends considerable time asserting the claim that California can ban commonly owned semi-automatic firearms as long as they permit Californians to acquire other firearms. But there is no constitutional support for this claim. And the state's attempt to force through outright bans on common firearms by referencing a sparse amount of fire prevention laws and restrictions on concealed carries, far removed from the founding era, and 20th century laws restricting machine guns, provide absolutely no support for their unconstitutional prohibitions. Okay, so once again, the case is Miller v. Bonta, and it comes in the Southern District of Southern California, and this is the challenge to California's semi-automatic rifle ban. So we have Miller v. Bonta on the West Coast. We have Bianchi v. Frosch on the East Coast. These are two cases that we need to very, very carefully watch. We'll put the links for all of them down below so you can do exactly that. Listen, in the meantime, if you got any more questions about these bans or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.